Well, the mother of the Oxford High School shooter was back in court today fighting for a new trial. Jennifer Crumbley was found guilty of 4 counts of involuntary manslaughter last February. In December, her new attorney filed a motion to get the sentence overturned. The judge dismissed many of the new lawyer's claims. However, the judge did not make a decision on proffer agreements with 2 key witnesses, which would be a violation of the discovery rule. 7 News Detroit reporter Sarah Michaels spent today at Oakland County Circuit Court hearing arguments from both sides.
Essentially, this argument boils down to one question. Should the prosecution have told the defense about these proffer agreements or not? Inside of this courtroom, the judge said that she was very interested in hearing both sides, saying a proffer agreement argument isn't something that she's heard a lot about before.
Very, very interested in hearing arguments about the proffer.
What exactly is a proffer agreement? It's a legally binding contract between a defendant or witness and a federal prosecutor. In this case, it allows the witness to provide information on the stand with the agreement that the government won't use it against them in court.
They dangled that carrot over those witnesses to get them to cooperate.
The 2 proffer agreements Jennifer Crumbley's new attorney, Michael Desky, brought up Friday in court were the ones the prosecution made with Oxford High School counselor Sean Hopkins and former dean of students Nicholas Ejak. The prosecution did not tell the defense about the agreements during the 2024 trial, which Desky argues is a violation of the discovery rule, which requires the prosecution to provide any plea agreement, grant of immunity, or other agreement for testimony in connection with the case.
Those school officials who sat down with the prosecutor's office could say anything they wanted to in that room, knowing whatever they said could not be used against them at any later time. That is a grant of use immunity.
The prosecution argues Desky's claim, saying there was no discovery violation. The witnesses were not required to testify, and there was no immunity guaranteed.
There was no grant of immunity, Judge.
It's not use immunity?
It is not, Judge. The only way to grant immunity is to petition a court for immunity.
Nicholas Ejak and Sean Hopkins met with the Oxford school shooter and his parents, Jennifer and James Crumbley, the day of the shooting. Each was a witness that Jennifer Crumbley did not search her son's backpack or take him home that day. The defense argues without their proffer agreements, their testimony would not have been heard.
They had an absolute duty to produce those agreements, and those agreements could have changed the outcome of the case. I'm just getting started here.
There was no conspiracy and there was no decision to hide. We don't keep secrets. We don't hide anything.
At the end of court today, the judge said she will take some time to think over her decision. We will let you know as soon as that decision is made. At Oakland County Circuit Court, Sarah Michaels, 7 News Detroit.
We shall see where it goes. Thank you, Sarah.